Morning everybody. Gosh, that's a bit of a loud microphone, isn't it? I'm glad I've got you all first thing, so hopefully the caffeine's going to start kicking in and you'll actually be paying attention. If anything I do tell you this morning is unclear, feel free to grab myself or one of my colleagues from Definitive. We should be identified with our distinctive name badges to go through any queries that you may be having on it. In case any of you don't know me, my name is Dan J. I'm a senior consultant here at Definitive. And we thought it would be a good idea, before we run into what's going to happen in 2014, to just give you a quick reminder of what changed in UK immigration in 2013. I'm going to be stepping back in time a little bit. You should all have slides as well in your packs to follow. And again, if anything is unclear, if you can't make out those facts and figures, just come and grab one of us and we'll happily run it through with you. So 2013, it goes without saying that it was a very politically charged year for immigration. Lots of policies and procedures were changing as a result of the political agenda here in the UK. Interesting point to note is that the UK Independence Party, aka UKIP, also grew its membership by up to 10% of the electorate. As I'm sure you all know, it's a very anti-EU policy party, which may or may not have some effects on immigration and legislation in the forthcoming year as well. Very interesting to know that migration into the UK actually has decreased in the last officially released figures. As hopefully you can tell from this slide, in September 2011, immigration to the UK was at 581,000 people, whereas in 2012 it was actually 495,000. So just to put into context, it does show you that immigration has actually fallen to the UK despite what you may be reading in the press. To give you some also point of perspective, it's interesting to note that in 2012 it was recorded that there were 4.85 million non-British people in the UK. That also means that there was 7.68 million people in the UK that were actually born abroad. Based on the World Bank, there are actually 62 million people here in the UK, so that will put it in some perspective for you what figures we're talking about and what the press is actually talking about when you read facts and figures about immigration. It also goes without saying that there's a very strong public opinion on immigration at the moment. People are being swayed by what they're reading and what they're hearing about in the press. So if anything you feel is controversial, anything you don't really agree with, do give us a shout. We're more than happy to hear your opinions and share them to the interested parties that we also work alongside with. So why are you all here? Wanted to run through some of the changes in 2013 to employment-based immigration. I'm sure that you are all Tier 2 sponsors, or at least I hope you are, or planning to be very shortly. For those people that are Tier 2 sponsors, there have been some huge changes to Tier 2 that you should hopefully now be aware of. The most important one, arguably, in my opinion anyway, is the Standard Occupational Codes, the SOC codes as they're also known as. They went under a huge transformation in April 2013. Essentially, these are the codes that you need to slot and fit your Tier 2 workers into. Anyone that you want to sponsor into Tier 2, you need to make sure that they actually meet these SOC codes. The SOC codes will then tell you what job duties your Tier 2 workers should be doing, and they'll also give you an indication of what salary you should be paying them as well. In April 2013, the Home Office decided to radically change the way that these are going to operate, whereby they now introduce two different categories of people that you need to put your workers into. So nowadays you need to identify people under new entrants or under experienced hires. What's the difference? Why do you care? You should care. Because new entrants, you can actually pay them a much lower salary than the experienced hires. And the new entrants are those people such as your Tier 4 students switching into Tier 2, maybe your Tier 1 post-study workers who are going to switch into Tier 2, and also anybody that's aged under 26 at the time of their application. I'm not going to say anything about age discrimination here, of course. You need to be aware of this because whenever you slot somebody into a Standard Occupational Code now, you need to be aware of what the salary expectation is going to be for them in 3 years' time when they come to extend their visa. Because the big shift now is that there are huge salary jumps between the SOC codes. Essentially what I'm trying to get across is, as sponsors, you need to be aware of what codes you're going to be putting people into and make sure that in 3 years' time, when you come to extend their visa, you can actually afford to pay them the experienced hire rate. And there are some very big jumps between the two of them. A couple that I wanted to point out, just to make you aware, are advertising managers. When they first join you as a new entrant and you first sponsor them under Tier 2, you only need to pay, but you need to just be paying them a salary rate of £21,000 a year. However, in 3 years' time, when they become an experienced hire, you need to be paying them £27,000 a year. Anybody in the IT industry, you should be concerned about this. IT is the industry that's been the biggest hit by the subcode changes. The best or worst example to be giving you is anybody who you're bringing on into the UK as an IT manager. When they first start, you need to be paying them a salary rate of £25,500 a year. However, in 3 years' time, that's actually going to jump up to £40,000 a year. If you can't afford to pay that £40,000 a year, unfortunately, you can't keep that person on in the UK. My maths isn't that great, but that's about a £5,000 pay rise, £5,000 pay rise a year, which is pretty nice if that's what your company can offer. So do bear these in mind. Make sure that whenever you're first assigning a Tier 2 certificate of sponsorship, you know what the difference is between your new entrant and your experienced hire rates. Another interesting change that happened to Tier 2s that are going to affect sponsors is a big shift between intracompany transfers. Up until 2013, anyone that wanted to extend their stay in the UK as an intracompany transfer needed to prove that they could actually speak English language when they came to extend their visa. However, nowadays they don't need to do that. The Home Office have completely dropped the requirement for people to be able to speak English when they're extending their visa. Why is this important? You actually don't need to make sure that your intercompany transfers can actually speak English. It's actually quite a good thing for your companies. And it's also a really good point to show that the Home Office do bow to pressure. They faced a lot of pressure and a lot of scrutiny and lobbying from ourselves, but also from some large Japanese organisations where their employees weren't able to actually speak English. And it shows that the Home Office do listen to concerns, they do listen to queries, and ultimately, if you put the right representations in, your representations can be heard by them and policies actually change. For Tier 2 as well, it's interesting to note that despite these changes, there's actually been a big jump in Tier 2 applications. You may think that the Home Office changing these regulations and rules on a regular basis may mean that people are going to be put off from applying for Tier 2 applications. Well, actually the figures tell us the opposite story. We can see that in July to September 2012, there were 11,161 Tier 2 applications filed, whereas for the same period in 2013, that's actually jumped up to 13,819. So don't be put off is the aim. I found it quite interesting, I hope somebody in this room will agree with me, but I found it quite interesting that the Home Office were quite proud to be announcing that the majority of Tier 2 applications were from Asia, with the Americas being the second highest continent where applications derive from. And bear that in mind when it comes on to a few slides later. There's also, to think about something positive here though for sponsors, I'm trying to find a positive here for somebody. There has been a dramatic reduction in sponsor case working times. Anyone that hasn't applied for a licence yet, that's going to apply for a licence, you're actually in a really good position because nowadays the Home Office are processing sponsor licence applications in about 2 to 3 weeks, whereas at the same time last year it took 2 to 3 months. This also applies to any changes to your sponsor licence, if you're changing some key personnel, if you're updating your branches, for example, for your intercompany transfer links, if you're adding other businesses to your sponsor licence, you're not going to have to sit there and wait 2 to 3 months nowadays. It will be done in a couple of weeks, which is brilliant news for sponsors. For sponsors as well, I'm going to go to a negative now. You do need to be aware of increased reporting duties. I'm sure you all know that when your Tier 2 people are leaving the UK, you need to notify the Home Office of that fact that they're actually leaving. The big change that happened in April last year is that you now need to report the exact date that person left employment in the UK. It's no longer feasible for you just to put in a report saying that this person's left. It's now mandatory for you to put the exact date that that person left employment. Out of curiosity, any volunteers want to volunteer the information as to how long you have to report that information to the Home Office? Yeah. Perfect, 10 working days. Someone's paying attention, that's great. So yes, you need to be reporting that within 10 working days. So it goes without saying that if you put a date on your report that's outside of that 10 working days, what the ramifications are going to be. It's not going to look good on you as a sponsor, and it's also probably going to draw some questions from the Home Office as to why your report is being so late. The Home Office also now require you to notify them of your Tier 2 worker's last known residential address, contact phone number and email address. So again, it's no longer feasible just to write a short note saying that Mr. or Mrs. X has left the UK. You actually need to give them all these details. If you don't, they'll simply come back to you and ask for it. So do bear that in mind as well for sponsors. Keep on top of the information you record for your migrants and make sure you give that to the Home Office on a timely basis, of course. Two quick other things I wanted to point out is that there have been some changes to the resident labour market test or the advertising process that you need to go through whenever you're going to sponsor somebody under Tier 2 General. Even though you might be paying somebody a really high salary of £71,000 a year, you actually still need to now advertise that position on 2 different websites. It's something that the Home Office didn't publicise that much or didn't publicise that well, but you do need to be aware of it. They may have dropped the requirement for you to advertise on Job Centre Plus, but you still need to advertise that position somewhere else. The Home Office have also slowly but surely been introducing a passport return scheme for Tier 2 applications. Anyone that submits Tier 2 applications by post, you know that they take about 2 to 3 months to process, and people are having to give up their passports for that period of time as well. However, nowadays there is a passport return scheme available where the Home Office will actually return that applicant's passport to them in about 10 working days. Do just bear in mind, it's a great scheme, it's a good thing that they're operating, I'm not complaining, but the one downside is that people still can't travel. If their visa has expired, they still can't come back in. So they do need to make sure if they're going to travel, that they still have a valid visa to come back into the UK. A couple of points to remember in 2013 that may affect you as sponsors are some changes to private immigration routes. 2 of the most important things that I wanted to highlight with you are the changes to family appeals. Essentially, any one of your employees that's making a family-based application to come into the UK, if something goes wrong with that application, they no longer have the right of appeal. There's no automatic right of appeal for them anymore. So you need to make sure that their applications are 100% perfect before they go in. The only time they'll get to appeal that decision is if there is a potential human rights or race discrimination ground, which I very much doubt unless you can prove that. So you have to make sure that if anyone's submitting any of those cases, they are 100% perfect to begin with. Dependents as well. Any dependent that wants to switch their immigration status in the UK, so somebody, for example, that's here as a student that may have got married to a British or European national, or even may have got married to another Tier 4 student, they can now switch their status in the UK. Beforehand, they would need to go back home, file a fresh visa application. Families would be separated for about 2 to 3 months while these applications were being processed. Nowadays, they don't need to do that. They can actually stay here and make their applications, which is good news. Settlement, also known as indefinite leave to remain or permanent residency. There have been a couple of changes at the end of 2013 that you all should be aware of by now, I hope. The Life in the UK test, the very fabled test that all migrants need to take to prove that they know about life in the UK, that test has finally been revised. It was kind of a running joke in the Home Office that the test hadn't been revised for about 5 to 6 years. So migrants were having to learn facts and figures about the UK that were completely out of date. But thankfully, this has now been brought into line. So do make sure if anyone's going to be taking the Life in the UK test, they get the new book. Don't let them use one of their colleagues' old books. Make sure that they buy and read the new book. The Home Office have also introduced a mandatory speaking and listening test for all applications for settlement. What this means is that any migrant that's going to settle now in the UK, they need to prove that they have an adequate knowledge of the English language, being able to speak it and being able to listen to it as well. If they don't submit that with their applications, they'll simply get refused. If that does cause concern for anyone in the room, just come and find one of us. We can chat you through how that actually works and what that might need to prove. EU migration, I don't really know where to start with this one, to be honest. Barely a day goes by nowadays without Romania and Bulgaria being on the front page of any newspaper. So it goes without saying, for you as sponsors, you should now well know that Romania and Bulgaria are now completely free of immigration control. They don't need to get any work permits, they don't need to get any work visas before they come over to the UK. They can simply rock up and start to work with you as any other European migrant. All restrictions have been removed on them, although they are subject to some strict rules and regulations on when and how they can claim benefits. Hopefully that's not going to be a cause of concern for anyone in this room. Fees. It's quite interesting to note that the Home Office in 2013 have introduced fees now for European applications. Arguably, it may not be compatible with European law, however, no one's yet challenged this, so do just bear this in mind. It's a nominal fee, it's not a huge fee, but do just bear that in mind if you're going to process any European applications for your workers, that there are going to be additional Home Office charges to pay as well. And also just one thing to point out is that Croatia actually joined the EU in 2013. Did anybody actually know that? No? Yeah, you've all been focused on Romania and Bulgaria, haven't you? But Croatia actually joined the EU in 2013. They are still subject to other rules and regulations like European countries. So if you do have anyone approaching you from Croatia, just give us a shout or check our website for further information. I thought it'd be quite interesting to run through with you what the Home Office have tried to do in 2013 to increase their priority services across the world. Essentially what they're starting to do is introduce a very quick, very streamlined visa application processes. One important change has been the introduction of what's called a registered traveller scheme. People from the US, Canada, Japan, Australia and New Zealand can apply for this if they're coming here on a business visit or a regular visit to the UK. Ultimately, what it means is that if they're coming here to visit and they apply for this scheme, they can be fast-tracked through immigration control. They don't need to stand and queue in those 2-hour-long queues at Heathrow or Gatwick. They can simply walk through quicker electronic gates to get into the UK, which is a great benefit. You've also probably heard a lot about the UK trying to increase trade in India and China. As a result, there are now super duper priority services in both India and China for business visitors, whereby they can simply get a visa application appointment and decision within 24 hours. Again, bear that in mind in future slides. It should also be pointed out that the Home Office have just introduced a brand new and their first ever electronic visa waiver scheme for people from Gulf countries that are coming here on visits as well. Essentially what this means is no visa is going to go in these people's passports. It's just like an online application form similar to British or European people now going to the States. You fill out an online application form and get an electronic permission to enter the country. The Home Office are now going to do this for people from Gulf countries coming here on visits. If you take a look at our newsletter in your packs as well, it won't take Einstein to figure out why the Home Office have introduced that for those countries. I'm going to end on some controversies and scandals. Ultimately, it would be the Home Office without controversies and scandals. The most important of which to note is that the UKBA, UK Border Agency, has disappeared. That doesn't exist anymore. If any of you in your literature still have the UKBA or UK Border Agency, just do a find and replace on Word and get that updated, because it no longer exists. It was just completely dismantled in April 2013. And is now being brought back into the Home Office. In January 2013, there was quite an interesting Channel 4 documentary, I don't know if anyone saw it, and also a lot of news reports about the Home Office having 14,000 cases stuck in a backlog, which of course created more bad publicity and bad press for the Home Office. It actually transpires that those weren't applications, these weren't people that had passports stuck with the Home Office. There was actually people that had put in requests for reconsideration of their applications. So again, it's really good to note that whatever you may be reading in the press, don't take it as a rule of thumb. Do check the facts behind it before you take it on board. And the final thing as well I wanted to point out is that you may recall Theresa May was quite proud to announce that she was going to be introducing visitor bonds to the UK. whereby anyone coming to the UK, whether it was for family or business or pleasure, would have to pay a fee of £2,000 to actually be granted this visa that would then be refunded when they left the UK and went back to their home country. Of course, there was a lot of controversy, a lot of furore from countries affected, which ultimately resulted in this policy being quietly swept onto the carpet. It was supposed to come into effect on the 1st of November, never actually did. So what does that show you? It shows you again that if you were strongly opposing a proposal, if you don't agree with it, get in touch with the Home Office, lobby them, we're happy to do it on your behalf. And it shows that they do listen to people when they do complain to them, and if they don't agree with any proposed agendas. Perfect. To summarise, there have been many changes in 2013. As sponsors, you do need to keep up to date on what's changing in Tier 2 rules and regulations. And with things changing on such a rapid basis, in 2013 alone, there were 4 rule changes that affected sponsors. If anything is unclear, do check our website, do just give us a call. We're more than happy to help. That's what we're here for. Thank you very much, and we'll pass you over to Helen.